Welcome to Introduction to Jurisprudence. This is the fifth in a series of 5 videos where we are looking at some foundational concepts in jurisprudence. In this video we're going to look at critical legal theory. Critical legal theory is an umbrella term for a range of different schools of thought within jurisprudence, and these various schools of thought are united by their critical perspective on the law and upon traditional understandings of the law. We're going to consider 4 particular critical legal theories. We're going to look at legal realism, the critical legal studies movement, feminist legal theory, and very briefly at critical race theory. So starting with legal realism, there is actually 2 schools of legal realism, one in Scandinavia and one in the United States. Here we are going to talk about the US version of legal realism, which was a movement that emerged within US law schools in the very early parts of the 20th century. Legal realism distanced itself from the more formalistic or scientific understandings of law that characterized legal positivism. Prior to legal realism, the dominant understanding of the nature of legal reasoning was that it was a formalistic and quasi-scientific process whereby lawyers and judges applied the correct law to the facts in the correct way in order to reach a legally correct conclusion. The legal realists rejected this formalistic approach. Instead, according to the legal realists, legal rules are not capable of yielding uniquely correct answers in any of the cases that come before the courts. In other words, there is no such thing as a legally correct decision. There are so many different legal rules that are potentially relevant to any legal problem or legal case that there is always support for both sides in a legal argument. There are so many different ways of interpreting legislation and so many different precedents that it's usually possible to locate either an approach to interpretation or a particular precedent that supports whatever argument one wants to make in a court of law, and that the choices that the judges make about which interpretation to use and which precedents to rely upon mean that it's possible for legal reasoning to reach any possible conclusion. You are no doubt familiar with the formalistic approach to legal reasoning. When lawyers or judges have to solve a legal problem, they identify the legal issue, they identify the relevant legal rules, they apply the rules to the facts, and they reach a legally correct conclusion. According to the legal realists, this is a fiction. What actually happens in the courtroom is that a judge, upon being confronted with a particular legal issue or a legal problem, reaches their decision on the basis of non-legal influences, their feelings about the case, or their intuition, or their particular fundamental beliefs or biases or prejudices. They then disguise that decision-making process with formalistic legal reasoning. And judges do not openly acknowledge the real causes of their decision because this would be inconsistent with the expectation that judges are impartial and objective and apply neutral and formalistic reasoning in order to reach their conclusions. What they actually do is reach their conclusions on the basis of non-legal means and then present their decision as if it were the impartial, objective, and rational application of existing rules to a particular situation. The realists argued that the essentially legislative or law-making nature of the judicial task should be acknowledged. They insisted that judges focus on the economic and social consequences of their decisions explicitly. They also argued that judicial choices should be informed by research in disciplines such as economics and sociology rather than formed on the basis of their particular beliefs or biases. Legal realism never really managed to topple the dominant or orthodox understanding of law and legal reasoning. In the US, it was in many ways assimilated into the common sense understanding of law that is taught and studied in American law schools. In Australia, legal realism was largely disregarded apart from the work of a few Australian legal academics. In the 1980s, however, some of the insights of legal realism re-emerged in the form of critical legal studies. There are many similarities between the critical legal studies movement and legal realism. Both stress the indeterminacy of law. the inability of law and legal reasoning to generate correct answers to legal problems, and the law's inability to constrain the decisions of judges, who are therefore thrown back on political choices. Like legal realism, CLS also claims that judges conceal the political nature of their choices by elaborate rationalizing exercises in so-called objective legal reasoning. In other words, like legal realism, CLS insists that judges make their decisions on the basis of political or other non-legal influences and then invent a legal reasoning process in order to justify the conclusion reached by non-legal means. CLS, however, went much further than legal realism, where legal realism was essentially consistent with liberal views and was an attempt to make legal decision-making more realistic or more accurate. CLS instead sees the law as fundamentally flawed in the sense that it is a tool of injustice. CLS scholars believe that the liberal values underlying the law are neither coherent nor desirable. A central objective of the CLS project is to expose the contradictions and incoherencies in the law which lie beneath law's surface unity and to undermine its appearance of coherence. In other words, they point out the ways in which various laws and our legal system as a whole is fundamentally contradictory and hypocritical. Now, of course, there is some predictability in the sense that we can often anticipate what judges are going to say when a particular legal problem arises. And the reason why judicial decisions can be predicted and that judges often agree on the answers to legal questions is not because the law is coherent or that legal reasoning can lead to correct legal answers, but because judges themselves tend to come from a particular political and social background and therefore tend to share certain political and social views. One of the central premises of the CLS position is that the law is fundamentally a tool for the advancement of particular political views. The law is a tool used by one group of people within the community, often identified as the rich, the white, and the male, to keep the majority of members of the community in their place. CLS is therefore even more controversial than legal realism, and in fact the notion that CLS can and should be taught to law students is itself a controversial one. Paul Carrington, the Dean of Duke University Law School in the United States, argued that the radical questioning of the legal order by the CLS movement and its apparent loss of romantic innocence and faith in the idea of law and its institutions meant that its proponents had an ethical duty to depart the law school. Dean Carrington even suggested that the cynicism of CLS could result in students learning the skills of corruption, bribery, and intimidation. CLS nevertheless shares many insights with feminist legal theory. Feminist legal theory is quite obviously the application of feminist perspectives and values to the philosophy and study of law. Feminism itself is both a political movement and an ideology. The objective of feminism is to expose and bring about the end of unfair discrimination against women. Feminism today is founded upon two claims. The first, that women should enjoy equal rights and opportunities to men, and secondly, that the ideal of gender equality is not presently realized, and for some degree of legal and/or social change is needed to achieve it. For many years, the battle was fought around the first claim, whether or not women should enjoy equal rights and opportunities to men. Today, most people accept that first claim, and the battle today is around the second claim, whether or not the ideal of gender equality has already been achieved. Many claim that it has, but feminists insist that gender equality has not yet been realized and that further change is required. Now, there are various forms of feminism, each of which has a particular view on the nature of law. Liberal feminism calls for the recognition of women's rights, paralleling the rights of men in liberal society. In other words, it's about ensuring that the liberal ideal of equality extends to women. Women should have the same rights as men. Liberal feminists believe in the capacity of law to achieve justice. So the law becomes a mechanism for ensuring that women have the same rights as men. Liberal feminists seek to reform laws that limit access by women to education, jobs, property ownership, and participation in political life. in other words, by granting women the right to vote. Formally, many of the aims of liberal feminism have already been achieved in Australia. Liberal feminists have successfully fought for women's right to vote, right to own private property and make contracts, right to litigate, and the right to employment after marriage. And today, liberal feminists focus upon achieving substantive equality for women. The second school of feminist thought is difference feminism. Whereas liberal feminism is about ensuring that men and women are treated equally by the law, difference feminism insists that there is a distinctly feminine way of approaching moral and legal problems. So whereas liberal feminism focuses upon the equality of men and women, difference feminism focuses upon the differences between the sexes and insists that the law recognize the differences between men and women and provide women with access to equal opportunities. Some difference feminists argue that women have distinctive values which are relational and are based on an ethics of care, whereas male ethics tend to be rule-based. So the difference feminists are arguing that law tends to favor a male-oriented approach to ethics and justice, and that the law should be reformed to better reflect feminine values and feminine priorities. The third school of feminist thought is radical feminism. Radical feminists insist that oppression on the basis of sex is the most fundamental source of inequality in society, and that it manifests in the form of patriarchal structures, including political structures, industrial organizations, religious establishments, etc. In other words, radical feminists insist that society itself is fundamentally biased in favor of male values and male perspectives, and that fundamental change is required in order to bring about some form of gender equality. Radical feminists argue that the institutions of law and the state reflect and reinforce male power. They seek more than mere legislative reform, rather they seek a radical transformation in the relationship between the sexes. Radical feminism also claims that many women suffer from false consciousness, that the messages which dominate society blind them to the reality of their oppression, and therefore a large part of the feminist project is about raising the consciousness of women who do not recognize the reality of their own oppression. The fourth feminist legal theory is postmodern feminism, which is the most recent to emerge. Postmodern feminism examines the ways in which language and reasoning themselves construct and not merely reflect or describe gender and sexual equality. Postmodern feminists also claim that other forms of feminism tend to essentialize women's experience, suggesting that all women experience oppression in the same way on the basis of sex. So postmodern feminism is critical of the absence of race, for example, in understandings of women's oppression, and the use of white, middle-class, heterosexual women as the model for all women. Postmodern feminism argues for recognition of diversity and an understanding of oppression through intersectionality, the combined effect of oppression on the basis of both sex and race. And that leads us to the fourth and final school of thought, critical race theory. As with feminism, there are a number of different ways in which race and racial discrimination have been theorized by scholars. In the US, critical race theory is one of the most important bodies of critical scholarship. And critical race theory is concerned with the study and transformation of the relationships between race, racism, and power. Critical race theorists insist that the orthodox legal system and body of legal rules is fundamentally biased in favor of a particular race or culture, typically white Western culture, and that other cultural perspectives, priorities, and values are marginalized or disregarded. Even the liberal notion of equality is criticized as being a Western or white standard with which all other races and cultures have to, or are expected to, comply. The ultimate goal of critical race theory is the establishment of a legal system that accurately reflects the diversity that exists within modern communities.